Afternoon, Supervisors. Thank you for allowing us this additional time to provide some information about some of our concerns with the way the Sheriff's Department is cooperating with ICE in this new legal environment where SB 54 imposes a lot of obligations and creates a lot of prohibitions. I'm going to handle the first part of the presentation on behalf of Sacramento Immigration Coalition. Rhonda Rios-Kravitz will then come up and provide some additional suggestions primarily. I would say when we were here last year, we had almost all questions and no answers. This year, we're at a very different place where we still have a lot of questions, particularly more acute, concerning questions, I would say, about the way that the Sheriff's Department is transferring people to ICE. But we do have some answers as well, and I'm going to try to get into those. We appreciate Sheriff Jones being here, but respectfully, his presentation that there's nothing to see here, I don't think accurately captures what's really going on. So our top line recommendation is that the board institute a prohibition against further cooperation with ICE at the county level. And there are several reasons why. One is that based on the data that the Sheriff's Department provided to the California Attorney General for 2018 transfers to ICE, there are a significant number of possibly illegal transfers and notifications that were made. Second reason is that we have independently verified a number of individual stories of what we are quite certain were illegal transfers. I'll get back to that in a little bit. And finally, the Sheriff's Department policies are confusing and fundamentally inconsistent with the law. And we'll get back to that briefly as well. So we did invite Sheriff Jones to meet with the coalition in a letter dated September 13th. And outlined a lot of our concerns in that letter. We have not been offered the chance to meet with him. The department did respond last Thursday evening, indicating that they thought that they had allayed our concerns by revising their policy. Although, as I'll mention at the end, we don't think they've actually done that. So we still would welcome the opportunity to meet with the Sheriff's Department and Sheriff Jones to discuss these concerns further. So, to get at what's going on here and what should be of great concern to the board, I think we need to talk about two aspects of the California Values Act, SB 54, that are sort of the linchpin of restoring trust between California immigrant communities and law enforcement. And one is this notification rule. Fundamentally, a law enforcement agency in California, the Sacramento Sheriff's Department, is not allowed to notify ICE of when it's releasing somebody unless very specific criteria are met. Those are the criteria set out in section 7285.5. Related to that, the Sheriff's Department is not allowed to transfer anybody to ICE unless the same criteria are met. So the criteria are outlined very specifically, and there ought not to be any confusion about what those are. In part, there's an absolute prohibition against notifying ICE or transferring somebody based on a simple misdemeanor conviction. And we'll get back to why that matters in a moment. Now, the Sheriff's Department provided the Attorney General information that it transferred a number of people based on charges that appear that they might be simple misdemeanors. This is not our interpretation. This is just looking at the penal code provisions that were listed out in the transfer information that the Sheriff's Department provided to the AG and being able to recognize those as simple misdemeanors. So by the Sheriff's own data, it appears that there were likely a number of transfers based on simple misdemeanors in 2018, all of which would have been unlawful under SB 54. We filed a subsequent Public Records Act request on September 24th, seeking additional information to try to get in more detail at what might have been going on there. We have not received a response yet. Okay, one of our big concerns about illegal transfers coming out of this information is that the Sheriff's Department indicated initially that 26 transfers were for people convicted of a misdemeanor DUI. In their email last Thursday, the Sheriff's Department reported that this was an oversight and that those transfers were actually based on a felony DUI statute. Okay, it's a little bit questionable just based on comparing those 26 purported felony transfers to transfer data across the state. For example, Los Angeles County, which has a population 6 times bigger than Sacramento County, had far fewer transfers for the same vehicle code offense. But even taking the Sheriff's Department at its word that that's correct, there's a big mystery. And that's because we verified several transfers in 2018 based on simple misdemeanor DUI convictions. We're continuing to investigate these stories about illegal transfers, but essentially by allowing these programs of notification and transfer to occur without oversight, supervision, or meaningful data collection, apparently, the county is creating conditions where it might have a massive legal liability on its hands in terms of illegal transfers and notifications. And it may be that some of these things are happening in the shadows where, there's an official policy and then there's an informal policy in terms of how things are actually done. And that again, would be really problematic. I know I'm basically out of time, so I'll just note.
Appreciate that.
Yeah, thanks very much for not cutting me off. Yeah. There's also this issue of the policies themselves inviting violations of SB 54. And again, we'd welcome the opportunity to work with the Sheriff's Department to try to refine those policies. They have not implemented our recommendations, which are exclusively designed to bring the policy into alignment with what the law requires.
Thank you. But before you leave, is there any question from the board?
I have a question.
Yeah, Mr. Cerna.
So you've cited the legislation that the legislative context for this several times. What does SB 54 say specifically about what happens if there's a violation of any element of the statute? What's the recourse?
SB 54 doesn't create explicitly a cause of action to sue, but I know that there are a number of tort claims percolating through the administrative and court process throughout the state, where the people making those claims have said that by being unlawfully transferred, that constitutes several torts under state law that are actionable. There's the bigger issue of if there's a pattern and practice of violating the law, then obviously there's the possibility for somebody who's aggrieved by that to file an injunctive relief lawsuit to try to stop that from happening. And
then in your opinion, is the county then liable then for any civil action that's brought against the Sheriff's Department?
These actions that have been filed under an administrative tort preservation posture so far, and then that are making their way into the courts, are against the county as well. I don't want to sort of start getting into what precisely I think the county's liability might be, but it ought to be a concern, in my opinion, for the board.
Thank you.
Supervisor Frost.
I wonder if the sheriff can respond to these, I guess, allegations.
Well, that sounds pretty salacious and scary, but the reality is we've made no illegal notifications. There's nothing operating in the shadows. What he is referring to, which he was corrected on last week, it's a little bit disingenuous for him to come up and say otherwise, was that last year as we were approaching this hearing, we had to get our information on which charges were given custody over to ICE from ICE itself. When we got the list, they were listed as DUI. And so through human error, we inadvertently reported that to the Department of Justice in January as the misdemeanor section of 23-152 of the Vehicle Code, but we went back and checked every single one of them, and they are all in fact under 23-153 or other felony sections of the DUI provisions, which is permissible to communicate with, cooperate with, transfer custody of, whatever you want to say, to ICE. There have been no unverified transfers, either formal or informal, that did not comply with appropriate law. Although he keeps mentioning individual stories and verified accounts, What I am not hearing is anyone specific. If Mr. Riordan has specific examples of folks that he would like me to investigate, believe me, I will investigate it, and I will either report back here, and certainly for my own edification, I will get to the bottom of what what did or what did not happen. But just to stand up here and say there are verified and individual documented cases without putting them in the letter so we could actually verify them, and then just to stand up here and allude that there's some cloud of disparaging conduct on the part of the sheriff's office, I don't think it's either fair, and I certainly don't think it's valid. So if there are verified information, I would ask him or the aCLU to provide that information so we could research it and get an answer for all of us, and not just kind of anecdotal, unverified information. Thank you.
I have one more question for the sheriff. Sheriff Jones, is it legal then, even though the county does not have a contract with ICE, is it legal for you to communicate with ICE?
So there's a couple of different aspects in answering that question. Number one is ICE can be provided with any information that's available publicly. So for example, whether like our database of folks that are in custody is public, folks that are sentenced and have a release date, that information is public, so they can get that information. If it's not available publicly, then they fall into one of two categories, one of which we can communicate with ICE about, one we cannot. So if they fall under the criteria of SB 54, where they are of appropriate crime, either serious or violent, or fit within the enumerated crimes and criteria, then yes, we can communicate with ICE, and that includes notifying them on the release. We could transfer custody of them, and I believe that occurred, I want to say 99 times. I think that's right, but it could be one or two the other way. That occurred with qualifying crimes 99 times in 2018. If it does not fit squarely within the criteria of that legislation, we cannot and do not have any communication with ICE at all. Not about anything, not about their release date, not about, wink, wink, they might be getting out. We absolutely and fully comply with the law. It makes better stories to allege that we don't, and that we're somehow have this sort of backdoor dealing with ICE, but the reality is it just simply isn't true. The confusing policy that he states, the original letter that he had issues and complaints about, referred to our old policy, which was rewritten in June or July for, frankly, it was for clarification and ease of use for our own staff, so they weren't as likely to make inadvertent mistakes, because there are some confusing aspects to the law. We provided a copy of that along with the fact back to Mr. Riordan last week by email, and mailed him a hard copy, I believe. But nonetheless, he got it last week, saying that a lot of the concerns that he'd raised relative to our old policy had been addressed in the new policy. Not all of them had, I'll be quite candid, because his reading of what the law requires in terms of a policy is different than mine. So reasonable minds are just going to differ on whether the policy requires things that I don't believe that it does. The one area that I will say that might have some merit that we are going to be looking into is he suggested that we should offer the additional languages of Hmong and Russian. Currently the statute requires 6 different languages, but it also requires, in addition to that, under 12.8.552 of the Health and Safety Code, any other languages for which the county population of a particular language speaking group is 3,000 or more, or any one zip code within that jurisdiction is 1,000 or more, or any cumulative 2 contiguous zip codes are 1,500 or more. And I would suspect, and we got our original 10 languages for our advisement that we use now, I believe, if I recall correctly, from the Registrar of Voters, because I think it's the same sort of criteria used for how to put out ballots in different languages. But I would suspect, as I stand here without knowing, that my guess is the Russian-speaking population, the Hmong-speaking population both exceed those 3,000 criteria, and of course our census may indicate even more. So, and has offered to help us with the translation. So if we will certainly be looking into that in terms of increase in the language availability and making sure that we are complying with that aspect of and being as inclusive with all the languages that the law requires.
And finally, is it safe to assume that someone who's looking from the outside in could actually maybe be making assumptions, but they don't really have, there's a lot going on behind the scenes, information that is not public information that they don't know, that so they could be making assumptions regarding the activities that go on between you and ICE that is not necessarily a good assumption because they don't have the information?
Certainly, but this is obviously a highly charged and political issue. And so, oftentimes it's in this arena, it's about controlling the narrative. And as I say quite frequently, that if you resort to emotional appeals and name calling, then facts generally are not on your side. So I'm here to present facts, and I'm happy to work with. I've set them up with my executive staff, my chief of corrections, and certainly I'm happy to meet with them. But frankly, it'd be more productive for them to meet with her and other members of my executive staff that are the boots on the ground, actually doing the work, that can provide the answers that they seek. And I think that we have gone a long way towards taking care of some of the concerns they had. I can almost guarantee you, as I stand here, we will never take care of all of the concerns that they have, because I think the aCLU on this issue and the sheriff's office come from fundamentally different places. But I can assure every one of you standing up here, as they're throwing out the specter of litigation and liability exposure, that we are 100% complying with the Trust Act and the Truth Act and every other piece of legislation that bears any weight of obligation on the sheriff's office and the manner in which we run our corrections.
Thank you, Sheriff.
Supervisor Natoli.
Yeah, I didn't have a question for Sheriff. I did want to ask Mr. Riordan something, though. It kind of pertains, so if I could...
You want Mr. Riordan?
Yeah, if I could, Sheriff, I want to ask Mr. Riordan. And it goes to a point that both of you spoke to, but you've indicated, and Sheriff's responded to this about, you said you've had verified cases. I gather from what the sheriff has said, you haven't provided either documentation behind that, or so is there some reason that problematic to do that? Because if you have solid verification and he's willing to look into it, then I think that information needs to be shared. I mean, again, I don't know why, if you bring that forward, you wouldn't present that to the sheriff and or his executive staff, and then and I guess attempt to re-verify it.
Yeah, it's a fair question, Supervisor Natoli, and I think that's something that we'll discuss coming out of this meeting. One concern has been that ICE has engaged in apparent retaliation against people who have spoken out. There was a Truth Act forum in the Central Valley where somebody was arrested within 24 hours of speaking at the forum. So people who have been previously arrested by ICE, released on bonds, and are now trying to keep their head down, can be concerned about that kind of thing. But I think we're going to have a conversation about it and figure out if that's something that we can do with the people that we have worked with on this.
Let me just offer a thought, Sean. It may be that, again, through, obviously aCLU, whether you represent those folks or not, through any litigation, but just as you put on the record today, obviously the sheriff is willing to take the information. Mr. Ferguson, in the county exec's office has sought information from other jurisdictions. Maybe there's a way to, again, I think provide some level of assurance that any concerns folks might have that have provided verification that you folks are comfortable with, relative to making the statement you made, a way to get that information in a fashion that certainly the sheriff would, honor the confidentiality of it. Obviously, maybe public record behind some of this if there are, offenses and arrests and so forth. But again, I would hope that we could get, the information to the parties that could then view it and then determine, certainly the accuracy as best people can, based upon obviously either, signed statements or, other information that you have available to you and the folks that you've been, that you represent, at least in the sense that you've made the statement here today. So I think that's important for all of us to know. So.
Absolutely, and one other just brief note on that. I mean, I do think the Sheriff's Department has the ability to undertake its own internal investigations. Sure. Obviously, from our perspective, if there was an objective third-party body a strong inspector general, for example, that could look into those things, that would also be exceptionally desirable.
Okay. Well, let me ask this then. I mentioned Mr. Ferguson, and he probably doesn't want to be in the middle of the crossfire here, but we don't have an inspector general in place as of yet. But you have been, your offices, Brett, have been helping with gathering information from the last truth forum. It may be with regards to this point, because I think it's an important point, you can maybe be the intermediary that helps to, provide the information. Obviously, the sheriff will have to do their own independent verification. But I would ask, since we don't have an IG, either that or maybe through the chair's office to assist in that regard. So particularly on that point, I think it's an important point. So I don't. Okay, thanks.
Thank you. Any other questions?